So now you've seen what Patton did. Swift, silent, devastating, no legal process, just judgment and exile. But here's the question you need to wrestle with. What if he'd done it differently? What if he'd used his legal authority, the formal court-martial system that military law provided? To understand why Patton chose the path he did, you need to see exactly what the alternative would have looked like. Not in theory, not in abstract legal terms, in practical reality, with real timelines, real consequences, real costs. Because when you see what court-martial would have actually meant, the choice becomes a lot more complicated than it first appears. The legal process. Under the Articles of War, the Military Legal Code in 1944, here's what formal court-martial for cowardice would entail. Phase 1. Formal charges. Week 1 through 2. The process starts with legal paperwork. Formal charges have to be drafted. Not just, this officer failed, but specific legal language, citing exact violations of military law. Article numbers, specifications, elements of the offense. Those charges get reviewed by Judge Advocate General officers, military lawyers who ensure they're legally sufficient. Can you prove each element? Is the evidence admissible? Are the charges appropriate to the conduct? The accused officer gets informed of the charges and assigned defense counsel a military lawyer whose job is to defend him. Time required, 7 to 14 days. Minimum. Phase 2. Investigation. Week 2 through 4. Before trial, there's an Article 32 investigation, the military equivalent of a grand jury hearing. A hearing officer reviews all the evidence to determine if there's sufficient basis to proceed to trial. Witnesses get deposed formally, under oath, with lawyers present. Not just quick interviews. Formal legal depositions where every word gets recorded. Evidence gets gathered and documented according to legal standards. Chain of custody. Authentication. Proper procedures. Defense counsel begins building the case, interviewing witnesses, gathering contrary evidence, preparing arguments. Time required, 14 to 21 days. Phase 3. Trial. Week 5 through 8. A court-martial panel gets convened. These are officer judges, typically senior officers who will hear the evidence and render a verdict. The prosecution presents its case. Witnesses testify. Documents get entered into evidence. Each piece of evidence has to be authenticated, its relevance established. The defense presents its case. Counter witnesses. Alternative interpretations of the evidence. Expert testimony. Witnesses get called and cross-examined. The defense attorney gets to challenge every piece of prosecution evidence, question every witness, raise every possible doubt. For serious charges, especially capital charges like cowardice in the face of the enemy, this process is thorough and time-consuming. Time required, 21 to 30 days. Phase 4. Verdict and sentencing. Week 8 through 10. The panel deliberates. Review all the evidence. Debates the credibility of witnesses. Decides whether the prosecution has proven its case beyond a reasonable doubt. The verdict gets rendered. Guilty or not guilty? If guilty, there's a separate sentencing hearing. More evidence, more arguments, mitigating factors, aggravating factors. What punishment fits the offense? The sentence gets pronounced. Time required, 7 to 14 days. Phase 5. Appeals. Week 10 through 16 and beyond. For serious sentences, there's automatic review by higher command. The case goes up the chain division commander, corps commander, army commander. Each level reviews for legal sufficiency and appropriateness. The defense can appeal, argue legal errors, challenge the sufficiency of evidence, request clemency. The higher command reviews everything again. Time required, 14 to 60, plus days, sometimes longer. Total time, minimum 2 to 3 months per case, often 4 to 6 months. Now, here's the critical context you need to understand. In those 2 to 6 months, the Third Army was advancing from France into Germany. They fought the battle for Metz. They crossed the Moselle River. They broke through the Siegfried Line. They advanced more than 600 miles. The war wasn't going to pause for paperwork. Those officers would need to be replaced immediately anyway. You can't leave companies and battalions without commanders for months while legal proceedings play out. So court-martial doesn't solve the immediate problem. You still have to relieve them and find replacements right away. The court-martial would be happening in parallel with the war, consuming time, attention, and resources that should be focused on fighting Germans. The defense arguments. And here's what makes court-martial even more complicated. Military defense attorneys were good at their jobs. They'd argue, the combat stress defense. My client experienced acute psychological breakdown. This wasn't moral cowardice, it was an involuntary physiological response to extreme stress. They'd bring in medical experts to testify about combat fatigue, about how the human nervous system responds to life-threatening stress, about how even strong, brave men can have their brains shut down under extreme conditions. They'd argue for medical discharge, not punishment. This was a wounded soldier, not a criminal. The unclear orders defense. The tactical situation was confusing. Radio communication was poor. My client made reasonable judgment based on the information available to him at the time. They'd challenge witness accounts, point out contradictions, raise questions about whether orders were actually clear, or if the situation was more ambiguous than it appeared in retrospect. The tactical positioning defense. For the Battalion XO case, battalion executive officers often coordinate from rear positions. This is proper command structure according to military doctrine, not cowardice. They'd bring expert witnesses, other battalion commanders, field manual excerpts, doctrinal guidance showing that command and control sometimes requires positioning yourself where you can see and coordinate the whole battlefield. And here's the problem with all these defenses. Some of them would work. Some officers might be acquitted. The prosecution might not prove its case beyond a reasonable doubt. A court-martial panel might decide that what looked like cowardice was actually combat stress, or tactical judgment, or simple confusion, which would be devastating. If Patton publicly accuses officers of cowardice, convenes courts-martial, and then some get acquitted, that's humiliating for the command. It undermines Patton's authority. It sends a message. Even Patton's accusations of cowardice weren't enough to convict, and it's terrible for morale, because now every officer knows you can fail under fire, get accused, go through a trial, and potentially get off. The deterrent effect collapses. The public scandal. But the real disaster would be the publicity. Court-martialing American officers for cowardice would create national news. Immediate headlines. American officers face execution for cowardice. The families of these officers would be contacted by reporters. They'd give interviews. My son is a patriot. He's serving his country. This is wrong. Public opinion would divide. Some would say Patton was right to maintain discipline. Others would say he was cruel, that these men deserved understanding and treatment, not execution. Enemy propaganda would exploit it. German radio broadcasts. American officers are such cowards. Their own general is executing them. The American army is falling apart from within. NHEM6. Congressmen would get involved. The families are constituents. They'd appeal to their representatives. Congressional inquiries. Questions to the War Department. Political pressure on Eisenhower. Questions about officer selection and training. If West Point graduates are failing as cowards in combat, what's wrong with our military education system? How many other officers are secretly cowards? Enlisted men would be reading about their officers being tried for cowardice. How do you maintain confidence in the chain of command when newspapers are running headlines about captains and majors being cowards? Other officers would watch their peers being publicly humiliated. The formal trial process would mean weeks of newspaper coverage, testimony, evidence, expert witnesses debating whether these men were actually cowards. Every officer in the Army would be thinking, if I have one bad moment, will that be me? Will my name be in newspapers? Will my family read about me being accused of cowardice? The British example. This isn't theoretical. We have a historical comparison. The British Army did use formal courts-martial for officer cowardice during World War II. Several British officers were court-martialed for cowardice or desertion. Some were executed. The exact numbers remain classified, but documented cases exist. The trials took months. They created publicity problems. They damaged unit morale. Soldiers reading about their officers being executed affected combat effectiveness. It became politically controversial. Families appealed to Parliament. The cases were debated in the House of Commons. Post-war. Many of these cases were re-evaluated. British military historians who studied these cases concluded that the formal process created more problems than it solved. The time costs were enormous. The morale damage was significant. The political complications lasted for years. Many now argue for pardons or exonerations of some of those executed officers, suggesting that the judgments were too harsh, that combat stress wasn't properly understood, that the system failed to account for psychological trauma. The contrast is stark. British approach: formal, legal, time-consuming, public, damaging morale. Politically controversial. Patton's approach: informal, quick, quiet, effective for missions, but denied due process entirely. Why execution didn't serve Patton's goal. Here's what you need to understand about Patton's actual goal. It wasn't punishment. It wasn't about making these men suffer. It was about maintaining combat effectiveness. Let's evaluate what execution through court-martial would achieve versus what Patton needed. Execution would achieve permanent removal of a failed officer. Yes. Deterrent effect. Yes. But it would also create massive time cost, 2 to 6 months per case. Publicity disaster. National news coverage. Morale damage. Troops reading about officer failures. Political problems. Congressional involvement. Doesn't get better officers into positions faster. You still have to replace them immediately. Quiet removal achieved. Permanent removal of a failed officer. Yes. Deterrent effect. Yes. Arguably stronger. Everyone knew the consequence was certain and immediate. Fast resolution. 24 to 48 hours instead of months. No publicity. Handled internally. Unit morale protected. No public scandal. No political complications. No congressional inquiries. Immediate replacement with better officers. New commanders in place within days. Failed officers were still useful. They could count supplies, process paperwork jobs that needed doing, but didn't require combat leadership. Patton's own words, documented in a staff meeting in August 1944, capture his thinking. I need combat leaders, not legal proceedings. When an officer fails his men, I need him removed immediately and replaced with someone who can lead. Courts-martial are for criminals. This is just removing unsuitable personnel from positions they can't handle. Notice what he's saying. He's not framing this as punishment for a crime. He's framing it as personnel management. Wrong person in wrong job. Remove them. Replace them. Move on. The effectiveness question. From a pure military effectiveness standpoint, the numbers tell the story. Third Army's performance during August through September 1944, the exact period when Patton was implementing his system, advanced more than 600 miles in 6 weeks. Destroyed or captured multiple German divisions. Maintained aggressive, effective leadership throughout every operation. Officer failures were identified and resolved without disrupting operations. No time lost to legal proceedings. No morale crises from public scandals. No political complications that distracted from the mission. The result: Patton's approach worked. The mission succeeded. The Third Army accomplished one of the most successful offensive campaigns in modern warfare. The pace, the aggression, the tactical excellence, it all continued without interruption. But here's the question that should be making you uncomfortable right now. At what cost? The mission succeeded. The Army won battles. The war advanced toward victory. But 3 men and at least a dozen others had their careers destroyed, their identities shattered, their sense of self-worth annihilated, without trial, without defense, without any process that acknowledged their humanity or their rights. Some of them probably deserved it. The battalion XO who deliberately avoided danger, you could argue he was calculating his own safety over his duty to his men. But some of them didn't. The staff officer who had a single psychological break, who'd served competently until that moment, whose own regimental commander wanted him medically evaluated rather than punished the system, destroyed him in exactly the same way. So now you see both paths. Formal courts-martial. Legal, fair process with defense rights. But slow, public, damaging to morale, politically complicated, and uncertain outcomes. Informal exile. Fast, effective, protective of the mission and unit morale. but zero due process and psychologically devastating to individual officers. Which would you have chosen? Here's the thing. There's no easy answer. And that's exactly why this story matters. It forces us to think about leadership decisions where all your options are bad and you have to choose the least bad one. Where fairness to individuals conflicts with effectiveness for the mission. Where doing the right thing isn't clear because there are multiple legitimate values in conflict. Patton chose effectiveness over process, mission over individuals, results over rights. He believed, and the results suggest he was correct, that his approach kept more soldiers alive. Having effective combat leaders in place immediately saved lives. That avoiding the distraction and demoralization of public trials kept the Third Army focused on fighting Germans. But he bought that effectiveness at a price. The price was paid by men who never got to defend themselves, never got to tell their side, never got a chance at redemption. Were those men owed due process? Yes, arguably. Under military law they had that right. Did their absence of due process save other soldiers' lives by keeping the army focused and effective? Possibly. Maybe probably. Can both things be true? That Patton's system was effective for the mission and unfair to the individuals? That's the judgment you have to make. If you're finding this analysis valuable, make sure you're subscribed, because the final chapter is going to ask you to make the hardest judgment of all. Now that you've seen the whole story, the failures, the punishment, the alternative, the question remains, was Patton right? Before you answer, you need to hear from everyone who had a stake in this decision. Because this isn't a simple question with a simple answer. It's a collision of competing values, and your answer depends on which values you prioritize. Let's hear from different perspectives. The ethical question. The officer's perspective. From post-war writings and memoirs, here's what the relieved officers said. It was profoundly unfair. We deserve the right to defend ourselves, to present our side, to have formal charges against us. Being relieved based solely on reports and Patton's judgment, with no opportunity to appeal or challenge the accusations, violated basic principles of military justice. We were professionally annihilated without even the dignity of due process. Their argument. Even in wartime, basic procedural rights matter. These aren't luxuries. They're fundamental protections against arbitrary power. Officers who'd served for years, who'd dedicated their lives to military service, earned the right to formal proceedings. They deserve to hear the evidence against them, to challenge it, to present their own witnesses, to tell their side of the story. No defense, no appeal, no second chance. That's not justice, that's arbitrary punishment. Patton acted as judge, jury, and executioner. One man decided their fate based on reports from others, with no opportunity for the accused to even speak in their own defense. Is this perspective valid? Absolutely. Due process exists for good reasons. It protects against errors, bias, and incomplete information. It acknowledges that human beings deserve dignity and fairness even when they've failed. Patton's perspective. From documented statements and his leadership philosophy, fairness to failed officers matters less than fairness to their soldiers. The men fighting and dying under incompetent leadership deserve immediate relief. Every day a failed officer remains in command is another day soldiers are at risk. The soldier's right to effective leadership outweighs the officer's right to procedural process. My job is winning the war and keeping soldiers alive, not running a legal system. His argument, soldiers' lives outweigh officers' careers. That's not cruelty, that's proper prioritization. When you're responsible for thousands of men in combat, your first duty is to them, not to the procedural rights of officers who've proven they can't do their jobs. Speed matters in combat. Every day you wait for legal proceedings to play out is another day that company, that battalion, is led by someone who's already demonstrated they can't handle the pressure. More soldiers die while you're ensuring perfect procedural fairness. Mission effectiveness is the highest priority. Wars aren't won by legal systems, they're won by effective leadership. Patton's job was to defeat the German army, not to run a court system that makes everyone feel good about the process. And the officers weren't treated cruelly. They kept their pay, kept their rank, kept their position in the army. They just couldn't lead in combat anymore, which was exactly appropriate given they'd proven unable to do so. Is this perspective valid? Yes. Leaders do owe their people competent leadership. The soldiers who had to follow these officers into combat their interests matter too. The soldier's perspective. From unit histories and veteran accounts, we depended on our officers to make split-second decisions that determined whether we lived or died. When an officer froze or failed, men died. We needed them replaced immediately, not months later after a trial. Patton's system meant we got competent leaders fast. That saved lives. Their argument: combat doesn't wait for legal proceedings. When your company commander freezes during an assault, you can't tell the Germans to hold their fire for 3 months while the army conducts a proper court-martial. They didn't care about officers' careers, they cared about surviving. That's not callous. That's the reality of being under fire. You need leaders who can function. If they can't, you need them gone, and replaced with someone who can. Quick replacement meant better odds of survival. Every day they had a competent commander instead of a failed one, increased their chances of making it home alive. The failed officers had proven they couldn't do the job. Maybe it wasn't their fault. Maybe it was psychological trauma. But regardless of why they failed, the fact remained: they couldn't lead in combat. The soldiers needed leaders who could. Is this perspective valid? Absolutely. The people most directly affected, the soldiers whose lives depended on officer competence, valued speed over procedural fairness. Their voices matter. The Army's institutional perspective: the relieved officers weren't executed, imprisoned, or dishonorably discharged. They remained in the Army, drew their pay, and could serve in capacities matching their abilities. They simply couldn't lead in combat anymore, which was exactly appropriate given they'd proven unable to do so. This was personnel management, not punishment. Their argument: the outcome matched the failure. If you can't lead in combat, you don't lead in combat. That's rational allocation of human resources. No one was treated cruelly or unjustly harmed. They weren't imprisoned. They weren't physically punished. They weren't stripped of rank or pay. They were reassigned to roles they could handle. Their skills were still used: administrative work, logistics, supply management. These jobs needed doing. The officers could still contribute to the war effort in ways that matched their capabilities. From an organizational standpoint, this was efficient personnel management. A wrong person in the wrong job equals bad outcomes. The right person in the right job equals better outcomes. Is this perspective valid? From a systems perspective, yes. Organizations need to match people to roles they can actually perform. What different values prioritize? Your answer to "Was Patton right?" depends entirely on which values you prioritize. If you prioritize individual rights, due process matters even in wartime. Everyone deserves formal charges, the right to mount a defense, the ability to appeal. These aren't negotiable. They're fundamental human rights that can't be suspended just because it's inconvenient or time-consuming. From this framework, Patton was wrong. And this is a valid ethical framework. If you prioritize collective welfare, soldiers' safety matters more than officers' procedural rights. The greatest good for the greatest number. One officer's right to due process doesn't outweigh hundreds of soldiers' right to effective leadership that keeps them alive. From this framework, Patton was right. And this is also a valid ethical framework. If you prioritize effectiveness, results matter more than process. The mission is paramount. Whatever works is justified. The Third Army's job was to defeat the German army and end the war as quickly as possible, thereby saving the maximum number of lives overall. If bypassing legal procedures achieved that goal, it was the right call. From this framework, Patton was right. And this is also a valid ethical framework. If you prioritize justice as process, how you do something matters as much as what you do. Ends don't justify means. Fair procedures are non-negotiable because the process itself embodies our values. If we abandon fair process to achieve good outcomes, we've already lost something essential about what we claim to stand for. From this framework, Patton was wrong. And this is also a valid ethical framework. There is no objectively correct answer. This is why the story matters. It forces us to wrestle with competing goods, not good versus evil. This isn't a choice between right and wrong. It's a choice between different rights, different goods, different legitimate values that conflict with each other. What actually happened? Here's what the historical record shows. Third Army's performance during August through September 1944. maintained aggressive, effective leadership throughout the entire France campaign. No breakdown in command effectiveness. Officers were replaced seamlessly, units barely missed a beat. No public scandals. No morale crises from watching their commanders publicly tried and executed. No time lost to legal proceedings that would have distracted from the mission. The mission succeeded spectacularly. From a pure military effectiveness standpoint, Patton's approach worked perfectly. From a procedural justice standpoint, Patton bypassed established legal protections that existed for good reasons. Both things are true simultaneously. The system achieved its goal, maintaining combat effectiveness while denying due process to individuals. Success and injustice coexisting in the same decision. The modern context. How does this apply today? What can we learn from 1944 that matters now? What's changed since World War II? We now recognize PTSD and combat stress as real medical conditions, not character flaws. The military has support systems for psychological injuries. There's been a cultural shift. Seeking help for mental health is less stigmatized than it was in 1944. Medical discharge options exist that acknowledge psychological wounds are as real as physical ones. What hasn't changed? Combat still requires immediate, competent leadership. Failed leadership still gets people killed. Commanders still must balance individual welfare against unit effectiveness. The tension between fairness and speed still exists. You still can't leave a company without effective leadership for months while you ensure perfect procedural fairness. The modern military's approach. Faster medical evaluations. More options between full command and complete removal. Leaders can be temporarily relieved pending evaluation, given treatment, potentially returned to duty. Better mental health support. More nuanced understanding of psychological trauma. But, and this is critical, they still must remove failed leaders quickly in combat. The fundamental dilemma remains. If an officer can't function in combat, you need them out of that position immediately. The question is still, how do you do that fairly while also doing it fast enough to protect the soldiers under their command? We've gotten better at recognizing the why behind failure. We're more compassionate about psychological wounds. But we haven't eliminated the core tension between individual rights and collective safety. The timeless pattern. This story reveals something that transcends 1944 France. It shows us a pattern that appears across all human cultures and all eras of history. Social exile as punishment is universal. Ancient Athens had ostracism. Citizens could vote to exile someone from the city for 10 years. No trial, no specific crime needed. Just a vote that you needed to leave. Ancient Rome practiced exile beyond the boundaries cast out from Roman territory, forbidden to return. Medieval Europe had excommunication from the church, cut off from the religious community that defined social identity and access to salvation itself. Tribal societies practiced banishment, cast out from the tribe, forced to survive alone. The modern professional world has blacklisting, being cancelled, fired, and made unemployable in your field. Your professional identity destroyed, your community closed to you. The military context, relieved of command, exiled to rear areas, stripped of the identity that defined you. Why is social exile often experienced as worse than physical punishment? Because humans are fundamentally social creatures. Our identity doesn't exist in isolation. It comes from our place in the community, our role in the group, our relationships with others. When you're cast out from your community, you lose your identity. Who are you if you're not a combat officer? If you're not a member of the tribe? If you're not part of the church? You lose your purpose. What's your reason for existing if you can't do the thing you trained your whole life to do? You lose your belonging. The people who mattered, the community that defined you, you're cut off from all of it. But you keep living. That's the cruelty of it. You're forced to witness what you've lost, to exist in a state of permanent exile, to watch others occupy the role you can no longer fill. This is why Patton's punishment was described as worse than death. Not because it was physically painful, there was no physical pain at all, but because it destroyed identity while forcing the person to continue existing without it. Death ends everything. Exile makes you live through the death of who you were while your body keeps breathing. What you should take away. Historical understanding. You now understand how World War II combat leadership actually worked. The impossible pressures commanders faced. What Patton was dealing with, and why he chose the path he did. The difference between having legal authority and exercising practical wisdom. Leadership lesson. Sometimes all your options are bad. There's no good choice, only less. Bad choices. You must choose the least bad option, even when every option carries a real cost. Effectiveness and fairness sometimes conflict. You can't always have both. Speed versus thoroughness is a real trade-off with real consequences. Ethical insight. Reasonable people can disagree based on prioritizing different values. Both can be right from their own frameworks. Context matters enormously. The ethics of wartime are different from the ethics of peacetime, and that's not necessarily hypocrisy. Competing goods are harder to navigate than good versus evil. When both sides represent legitimate values, when you're choosing between two rights rather than between right and wrong, there's no clear answer. Your answer to, was Patton right? Reveals what you value most. Individual rights? Collective welfare? Procedural justice? Mission effectiveness? All are legitimate values. Which one takes priority for you? Human nature. Social death can be worse than physical death for creatures whose identity depends on community. When your identity is tied to your role and position, exile from that role is existential destruction. In honor-based cultures that value reputation over individual life, this pattern becomes even stronger. And this pattern repeats across time and cultures. It's not specific to 1944 or the military. It's something fundamental about human social nature. The final question. So, was Patton right or wrong? The honest answer. It depends on what you value and what you think leaders owe their people. If you believe due process is sacred, that procedural rights can't be suspended even for good reasons, he was wrong. If you believe mission effectiveness is paramount, that winning wars and saving soldiers' lives justifies bypassing procedure, he was right. If you believe soldiers' lives matter most, that their right to competent leadership outweighs officers' right to formal trials, he was right. If you believe individual rights can't be sacrificed for collective benefit, that the process itself matters more than the outcome, he was wrong. All of these positions are defensible. Thoughtful people can arrive at different conclusions based on different but equally legitimate value systems. What Patton did was effective. Whether it was right is something each person must decide for themselves based on what they value most deeply. The value of this story isn't giving you the answer, it's teaching you how to think about impossible choices. When you're in a position of leadership and all your options are bad, you'll remember Patton's choice. You'll understand that. Legal authority doesn't equal wisdom. Having the right to do something doesn't make it the right thing to do. Fast solutions have costs. Speed protects some people, while denying others their rights. Fair processes have costs. Thoroughness takes time, and that time might cost lives. Someone will always pay a price. The only question is who pays it and how much. You have to decide what price you're willing to impose and on whom. That's not avoiding responsibility, that's accepting it fully. That's the real lesson. Not that there's a right answer. But you have to wrestle with these questions honestly. Understand the competing values at stake, acknowledge the costs of every option, and then make a decision you can defend knowing that reasonable people might disagree with you. So what's your verdict? Was Patton right to bypass military justice and destroy these officers' careers without trial? Or should he have given them formal courts-martial, even if it cost time, created scandals, and damaged morale? There's no easy answer, and that's exactly why I want to hear your perspective. Drop your thoughtful analysis in the comments. And if this story made you think about leadership, justice, and impossible choices in a new way, share it with someone who needs to wrestle with these questions. Because the leaders who think deeply about ethics before they face these dilemmas are the ones who make better decisions when the moment comes. Thanks for watching, and I'll see you in the next one.